Does all the deceased's property have to go through a succession? Attorney Gordon Crawford explains. It is not necessary that all of a deceased's property go through a succession. If there are only certain types of assets that the descendant leaves when he dies, then you do not need to go through a succession at all to transfer the ownership of the descendant's assets to his heirs. If the assets of the estate consist only of an IRA account or a 401k account, which is payable to a named beneficiary, these accounts will pass to that beneficiary and it will not be necessary to hold a succession. The same holds true in the instance that a life insurance policy has a listing of benefits as being payable to a named beneficiary. Those benefits would pass to that named beneficiary, and it would not be necessary to have an estate succession if that was the only asset a descendant owned. It could be a combination of a 401k account and a life insurance policy. All those asset proceeds would pass outside of an estate succession. There would be a similar result if you had an annuity policy where benefits passed to named beneficiaries outside of a succession. Recently, revocable living trusts have become popular. If they are properly set up, the potential succession assets can pass outside of the estate succession. This trust is revocable during the lifetime of the beneficiaries of the trust. It says who gets it at the end when the last named beneficiary dies. But unless this type of trust is drafted by a very skilled attorney, the trust assets may end up in a succession after all. If you or a loved one have been injured, you need someone who is experienced at protecting your rights and is dedicated to helping you stay informed through this difficult time.